Members of the jury, the duties of counsel in the court have been performed. The case has been argued by counsel. The court has instructed you regarding the rules of law that should govern you in your deliberations. The time has now come when the great burden of reaching a just, fair, and conscientious decision of this case is to be thrown wholly upon you, the jurors, selected for this important duty. You will not be swayed by sympathy, prejudice, or passion. You will be very careful and deliberate in weighing the evidence. I charge you to keep your duty steadfastly in mind and, as upright citizens, to render a just and true verdict. You are to decide only whether Mr. Mew is guilty or not guilty of the offenses charged. Any consequences of your verdict are matters for the court alone to decide, and they must not affect your deliberations. Multiple forms of verdict will be submitted to you concerning the charges against the defendant, Nikolai Mew. For count 1, 5 forms of verdict will be submitted. They read, as to count 1 of the information, Isaac Schumann, the jury finds Nikolai Mew guilty of first-degree intentional homicide as charged. Another form, as to count 1 of the information, Isaac Schumann, the jury finds Nikolai Mew guilty of second-degree intentional homicide as submitted. Another form, as to count 1 of the information, Isaac Schumann, the jury finds Nikolai Mew guilty of first-degree reckless homicide as submitted. Another form, as to count 1 of the information, Isaac Schumann, the jury finds Nikolai Mew guilty of second-degree reckless homicide as submitted. Lastly, as to count 1 of the information, Isaac Schumann, the jury finds Nikolai Mew not guilty. Return only one for your verdict. If you return a guilty verdict, you must also answer this question. Did Mr. Mew commit the crime while using a dangerous weapon? As to count 2, 5 forms of verdict will be submitted. They read, as to count 1 of the information, Alexander Martin, the jury finds Nikolai Mew guilty of attempted first-degree intentional homicide as charged. Another form, as to count 2 of the information, Alexander Martin, the jury finds Nikolai Mew guilty of attempted second-degree intentional homicide as submitted. Another form, as to count 2 of the information, Alexander Martin, the jury finds Nikolai Mew guilty of first-degree recklessly endangering safety as submitted. Another form, as to count 2 of the information, Alexander Martin, the jury finds Nikolai Mew guilty of second-degree recklessly endangering safety as submitted. Finally, as to count 2 of the information, Alexander Martin, the jury finds Nikolai Mew not guilty. Again, return only one for your verdict. If you return a guilty verdict, you must also answer the dangerous weapon question. As to counts 3, Dante Carlson, count 4, Anthony Carlson, and count 5, Riley Madison, the court will give you 5 verdict forms for each count that are worded similar to the ones given to you for count 2. As to count 6, Madison Cohen, 2 forms of verdict will be submitted. One reading, as to count 6 of the information, Madison Cohen, the jury finds Nikolai Mew guilty of battery as charged. Next, as to count 6 of the information, Madison Cohen, the jury finds Nikolai Mew not guilty. Again, if you return the guilty verdict, you must answer the dangerous weapon question. It is for you to determine whether Mr. Mew is guilty or not guilty of each of the 6 counts submitted to you. You must make a finding as to each count of the information. Each count charges a separate crime, and you must consider each one separately. Your verdict for the crime charged in one count must not affect your verdict on any other count. This is a criminal, not a civil case. Therefore, before the jury may return a verdict which may legally be received, the verdict must be reached unanimously. In a criminal case, all 12 jurors must agree in order to arrive at a verdict. When you retire to the jury room, select one of your members to preside over your deliberations. The presiding juror's vote is entitled to no greater weight than the vote of any other juror. If you need to communicate with the court while you are deliberating, send a note through the bailiff signed by the presiding juror. To have a complete record of this trial, it is important that you communicate with the court only by a written note. If you have questions, the court will talk with the attorneys before answering, so it may take some time. You should continue your deliberations while you wait for an answer. The court will answer any questions in writing or orally here in open court. When you have agreed upon your verdict, have it signed and dated by the person you have selected to preside. After you have reached a verdict, the presiding juror will notify the bailiff that a verdict has been reached. Everyone will return to the courtroom. The verdict will be read into the record in open court. The court may ask each of you if you agree with the verdict. At this time, please administer the oath to the bailiff.
Do you swear that you will, to your utmost ability, keep all jurors on this trial together in some private and convenient place, subject to the direction of the court, until they have agreed upon their verdict and that they are discharged by the court, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict that they have agreed upon, so help you God?
The bailiff has extra copies of the jury instructions. I imagine you'll probably want to consult with them during the course of your deliberations. I believe he has 4 or 5 sets. If you need more, let him know, and I will print more for you. He also has the verdict forms in each of the manila envelopes, 1 envelope per count. If you reach a verdict, please put that verdict, signed by the foreperson, back into the envelope. The other forms that you don't use can be discarded, but there only should be 1 verdict form returned back in each envelope. Now, members of the jury, as I mentioned to you at the beginning of the trial, only 12 jurors can deliberate. 2 alternates were seated in the event that we lost jurors due to health, emergency, or some form of misconduct. The alternates have been determined by lot by the clerk of court. The alternate jurors are not released from jury duty. Alternate jurors may be called upon to deliberate if we happen to lose one of the 12 jurors during the course of deliberations. So basically, the alternates are needed to be at the ready and stand by in the event that they are needed. The alternate jurors will be free to leave the building, but you may not talk about this case with anyone. You may not research or investigate the case on your own. You may not read social media posts. You may not read news reports about this case. If we need an alternate juror to participate in deliberations, the clerk of court will contact you, so we'll need a phone number before you leave. You will be expected to return relatively quickly. So please stay close to home or close to your place of work if it's nearby. We will keep your personal notes safe in a secure private location in the event that you're called upon to deliberate. At this time, I'll ask for the envelope. The 2 alternate jurors are Darren. You may. If you'd like to have a private place where you can eat it here in the courthouse, we'll provide you with that facility. But the alternate jurors may not eat with the other 12 because the other 12 may begin their deliberations once they are back in the deliberation room. Please take the jury out.
All rise for the jury.
Please be seated. Mr. Anderson, do you have any objection to the manner in which I read the jury instructions?
No.
Mr. Trofasi, do you?
No, sir.
All right. The alternate juror forms, or the alternate, I don't know what you call this, the jurors selected for the 12 jurors selected for deliberation are listed on the form if either of you need to see it. The clerk has it. You may look at it. Before we adjourn, attorneys, please stay close by in case there are questions. I do want to compliment both of you, actually all of you, on your conduct and demeanor during the course of this trial. It is difficult subject matter. It is difficult law to get your mind around. These were tragic events, traumatic events, and I thought you carried yourselves with dignity during these proceedings. And I think your clients, the victims, and the community should be proud of the way that you have administered justice today. You both have given this jury a lot to think about. We stand in recess.